Hi, this is Advocate Prashant Kanha. In this video, I am going to talk about the legal position relating with the law of bail, where the charge sheet has been filed by the investigating agency. However, during the investigation, the accused person who has been made accused in the charge sheet was not arrested by the investigating agency. Since the investigating agency did not arrest the accused person, there is very likelihood that the accused person may not have applied or have gotten anticipatory bail at that stage. So in this video, my presumption is that charge sheet has been filed against a person or against an accused who was not arrested by the investigating agency, and because there was no apprehension of arrest, as such even anticipatory bail was not taken by such accused person. And now charge sheet has been filed and the person is in a fix that what he should do. So under these circumstances, an accused person has two options. Number one, that the accused person can apply for anticipatory bail before the Court of Sessions against the summoning order or against the charge sheet, and if the bail is granted, well and good. Otherwise, again an anticipatory bail application can be filed before the High Court, and even if that is rejected, before the Supreme Court. So this is one option. However, then there is the second option, that is to apply for regular bail. Now when you apply for regular bail, it means that you have to appear before the court, give your custody to the court that I am present here and I am seeking bail. Now it will be dependent upon the court whether it wants to give you the bail on very same day, maybe interim bail, or regular full bail on the very same day, or it may fix the bail application for some other day, whereby it will provide some opportunity to the investigating agency or to the prosecution to bring on to file their reply or the counter against your bail application. Anyhow, it will also depend on whether you will get bail or not on the nature of offences which have been categorized by the Honorable Supreme Court in a recent judgment of 2021 titled as Satendra Kumar Antil versus Central Bureau of Investigation. In that judgment, the Honorable Supreme Court has categorized various offences into four categories. Category 1 or Category A includes those offences where the punishment is of up to 7 years. Means an offence has been committed or the charged sections under IPC are punishable by imprisonment of up to 7 years. The second category which the Honorable Court has categorized is or are the offences where the punishment is of more than 7 years or punishable by life imprisonment or by death. The third category of offences which have been categorized are offences under special acts which are grievous in nature. Let us say NDPS Act or Prevention of Money Laundering Act, UAPA, and other special criminal acts where the grounds or the grounds for the bail are very stringent. The fourth category which the Honorable Court has categorized is economic offences. When we talk about economic offences, these may include even offences under section 420 or Companies Act, fraud under the Companies Act, or it can be even 406, but that may have been done at a larger scale by the promoters or people involved in it. So these four categories have been created by the Honorable Court. So the court has also given direction to the district courts or the session judges that when they are considering bail application where the accused person was not arrested during the investigation, then if the offence falls under category A, that is punishable, maximum punishment is of up to 7 years, then the Honorable Court will entertain bail application without even taking the person into custody. That is, you can file your bail application even without surrendering, or If in case the person is surrendering, then the interim bail can be granted on the very same day and the main bail application can be decided on a later date. However, when the offences in category B, C or D come, then the court will have its own discretion. However, the person will have to give in the custody, and those matters will be decided by looking upon the severity of the offence charged against the accused person. When it comes to economic offences, the Honorable Supreme Court or the legal position is that it is taken as a very serious offence, and in the case of Sanjay Chandra in 2012, the Supreme Court has given guidelines or issued guidelines that whenever there are economic offences of large magnitude, then the corporate veal or negligence, all these things, beside these things being seen, the courts should also take into consideration the seriousness of the charge and also the severity of punishment when the matters of bail relating to economic offences are being considered by the honorable session judges or by the honorable high courts. So the overall conclusion is that if in case a person has not applied, is not on anticipatory bail and charge sheet has been filed against it, then firstly it can try his luck either by filing anticipatory bail, and if he could not succeed in that, then there would be another option of filing regular bail. And if the punishment is of less than 7 years, then without even giving his custody before the court or without even appearing before the court, he may file the regular bail application. But if the offences are punishable for more than 7 years or they fall under the special acts where the grounds of bail are stringent, then the custody has to be taken by the court first, and only then the bail application is heard. If in case the punishment is less than 7 years, then it is more practical to file for the regular bail application the moment summons are received, because if this gives an idea to the court that whether the accused is trying to not come before justice and trying to abscond. If let us say on summons the person is not present and then the BW is issued and NBW is issued, that will create a perception against the accused before the court. So it is always advisable that at the time of summons only, if the punishment of the charges are less than 7 years, then the person should immediately appear before the court and apply for bail. And even now the Supreme Court has given relaxation that even without appearance the bail application can be filed. So this is all with respect to position of law with respect to bail, where person was not taken into custody by the investigating officer but charge sheet has been filed. Thank you for watching this video.